Hello everyone, welcome to Manovidya IAS. Today we will look into the concept of reservation in India, and we will also analyze whether reservation is an harbinger of equality or inequality. So let's look into the context in which the issue has been arised. Yesterday, Centre requested the Supreme Court to refer the question of creamy layer to SC/ST class to 7-judge bench. And the actual question to 7-judge bench is whether the creamy layer concept should apply or not to the SC/ST class while providing them reservation in government promotions. In response, Chief Justice of India S.A. Bobde has agreed to hear the case after 2 weeks. In this week, let's look into the whole history of reservation. When our constitution was framed, the framers of our constitution made special provision with the intention to provide equal opportunity to all in public employment. The same was inserted in Article 16, which talks about equality of opportunity in matters of public employment. Since Article 16 is very important here, let's look into it in a detailed manner. Article 16 Clause 1 says, there shall be equality of opportunity for all citizens in matters relating to public employment. Whereas Article 16 Clause 2 says, no person shall be discriminated in public employment only on the basis of religion, race, caste, sex, descent, place of birth, or residence. However, there are three exceptions to this article. Article 16 Clause 3 says, Parliament can prescribe residence as a condition for certain employment. But as the Public Employment Requirement as to Residence Act of 1957 expired in 1974, there is no such provision for any state except Andhra Pradesh and Telangana. Article 16 Clause 4 says the state can provide for reservation of posts in favor of any backward class which is not adequately represented in the state services. Whereas Article 16 Clause 5 says religion can be ground for reservation if there is an employment in religious institutions run by the government. In connection to Article 16 Clause 4, two questions arises to our mind and are, who will be designated as a backward class people and who will be treated to be inadequate in the employment under the state? Since there is no provision in the constitution to answer these questions, then ruling party in 1953 appointed first Backward Classes Commission headed by Kaka Kalilkar. It is famously called as Kaka Kalilkar Commission. It submitted its report in 1955 listing out 2399 castes as socially and educationally backward, but the central government did not accept the report. Later in 1779, Janata Dal government headed by Morarji Desai appointed second Backward Classes Commission headed by B.P. Mandal. This is to investigate the socially and educationally backward classes and recommend some steps for their upliftment by giving equal opportunity in the public employment. The commission submitted its report in 1980, which identified about 3,743 castes as socially and educationally backward classes, and this forms nearly 52% of the population, and it recommended for reservation of 27% in government jobs for OBCs, that too excluding SC and ST. In the meantime, due to internal disturbance, Janata Dal government collapsed and thus it could not implement the recommendations made by Mandal Commission. After that, Congress government led by Indira Gandhi came to power, but she did not implement the Mandal Commission's report till 1989. In 1989, after winning election, Janata Dal again came to power. Then PM VP Singh issued Office of Memorandum in 1980 and reserved 27% seats for the socially and educationally backward classes. But this has led to eruption of anti-reservation movements for the next 3 months, and it has resulted in a huge loss of persons and property. Unfortunately, Janata Dal government collapsed due to defections, and in 1991, Congress again formed the government at the center. Then PM P.V. Narasimha Rao issued another Office of Memorandum by making two changes. First one is preference to poorer sections among the OBCs in 27% quota, that is, adoption of the economic criteria in granting reservation. Secondly, reservation to another 10% of vacancies for poor sections of higher castes who are not covered by any existing schemes of reservation. However, this was challenged in court by Bar Association of Supreme Court, and this case is famously called as Indira Savni case or Mandal case. Now let's look into arguments against reservation. Petitioner says the Mandal Commission recommendations are provoking the evil idea of caste system, which is nothing but considered as against the idea of secularism. Hence, Office of Memorandum issued on the basis of Mandal report, which is solely based on the caste criteria, is violating Article 16 Clause 2. If the recommendations are implemented, it would result in the substandard replacing standard and the reins of power passing from meritocracy to mediocrity. Then it would revitalize caste system and cleave the nation into forward and backward and make backwardness a vested interest. It would result in demoralization of the meritorious candidates appearing for the public employment. If the recommendations are implemented, the efficiency of administration will come to a grinding halt. Now let's look into the arguments in favor of reservation. Article 16 Clause 4 is a fundamental right under Part 3 of the Constitution. So, reservation based on social and educational backwardness is a fundamental right which cannot be taken over by anyone. The Mandal report is not solely based on caste system. It also considered social, educational as well as economic backwardness. Moreover, this reservation is made to provide an opportunity for historically disadvantaged groups to catch up with the standard of competition set up by a well-advanced society. Article 16 Clause 4 is to ensure equality of opportunity in public employment and give adequate representation to those who have been placed in a very discontent position from time immemorial on account of sociological reasons. After observing the arguments in favor and against the reservation, the 9-judge Constitution Bench of Supreme Court by 6-3 majority gave the following judgments. First one, backward class of citizens in Article 16 Clause 4 can be identified on the basis of caste system and not only on economic basis. The advanced sections among the OBCs should be excluded from the list of beneficiaries of reservation. That is, creamy layer is applicable to OBCs also. Here, creamy layer is a concept that puts an income ceiling on people availing of caste reservation in government jobs, education as well as promotions. This concept was first proposed by Satyanathan Commission in 1971. Further, it upheld by Justice Ramanandan Committee in 1993. Next one is no reservation in promotions. Reservation should be confined to initial appointments only. Next one, total reservation quota should not exceed 50% except in some extraordinary situations. The carry forward rule in case of unfilled vacancies is valid, but it should not violate 50% rule. Here, the reserved posts in a particular year must be filled on that year only. If the vacancies still left, they can be carried to next year, but provided next year's reservation should not exceed 50%. Next, a permanent statutory body should be established to examine complaints of over-inclusion and under-inclusion in the list of OBCs. And finally, reservation can be made by executive order. The decision of this case no doubtly laid down a workable and reasonable solution to the reservation problem, but in spite of that, the politicians have diluted the verdict of court by making 3 constitutional amendments. Now let's look into these amendments. 77th Amendment Act of 1995. By this amendment, Article 16 Clause 4A was inserted into the Constitution. This empowers the state to make a provision for reservation in matter of promotion to any class or classes of posts in the service of the state in favor of SC and ST. This amendment diluted the Supreme Court verdict of no reservation in promotions. Next, 81st Amendment Act 2000. It inserted Article 16 Clause 4B. By this amendment, it was fixed that Reservation can exceed above 50% for SC, ST and OBC if backlog vacancies which could not be filled up in the previous years due to the non-availability of eligible candidates. In brief, it ends the 50% ceiling on reservation in backlog vacancies. Next, 85th Amendment Act 2001. It provides for consequential seniority in the case of promotion by virtue of rule of reservation for the government servants belonging to SCs and STs. In brief, it relaxed seniority as a criteria for promotion of SCs and STs. Now, if you look at the Indra Savni case in the context of current event, Supreme Court upheld that there should not be any reservation in promotions, and subsequently it is diluted by 77th Amendment Act of 1995. The next case related to reservation in promotion is M. Nagaraj case of 2006. The Supreme Court in M. Nagaraj versus Union of India case upheld the constitutional validity of Article 16 Clause 4A and other amendments, and also told that such reservation policy should satisfy the following three constitutional requirements. The first one is SC and ST community should be socially and educationally backward. Secondly, the SC and ST communities are not adequately represented in public employment. And finally, such a reservation policy shall not affect the overall efficiency in the administration. Further, the state has to collect quantifiable data showing backwardness of the class. And finally, creamy layer is even applicable to SCs and STs in their promotions. But various states challenged Nagaraj verdict, citing the reason for lacks of vacancies due to the judgment. So, the correctness of interpretation given by Nagaraj decision was referred to Constitution Bench for reconsideration during 2017, that is Journal Singh case. So now let's look into 2018 judgment, that is Journal Singh case verdict. In 2018, five-judge bench of Supreme Court in Journal Singh case gave a verdict, and the judgment is as follows. First one is related to application of the creamy layer principle. Supreme Court ruled that the creamy layer exclusion principle, till date applied only to OBCs, can be extended to SCs and STs to deny reservation to the elite among the two communities. It upheld constitutional amendments leading to Article 16 Clause 4A. By this, the court asserted that the objective of reservation would not be fulfilled if only the elite group within that class bag all the coveted jobs in the public sector, leaving the rest of the class as backward as they were always. Next one is related to proof of backwardness of SCs and STs. Supreme Court held that state need not collect quantifiable data showing backwardness of SCs and STs. It even referred Indra Savni case which did not favor that requirement of quantifiable data. Next, reservation in promotion need not be in proportion to population. It noted that while the test of proportionality to the population is mandated by the Constitution in Article 330, that is, reservation of seats for SCs and STs in the Lok Sabha, it does not do so in the provision of reservation in promotions under Article 16 Clause 4A. But yesterday, the Centre requested Supreme Court to refer the question of creamy layer to 7-judge bench. Even CJI S.A. Bhobde has agreed to hear the case after 2 weeks. At this moment, we need to wait and watch. To sum up the concept of reservation benefits are cornered by few people who are comparatively better off than the rest. Moreover, it has attended the problem of middle class among SCs and STs and not the vast majority poor. The major problem is politicization of the caste. This has made many political parties as champions of reservation. And the irony is there is a competition among the castes to declare themselves as backward. Unfortunately, the new slogan is, "We are more backward than you." Then the question is, how will our society move forward? The reservations were supposed to be a part of the package to provide equality in the country, but the reservation has become the package in itself. It was supposed to be the means to achieve the goal of equality, but unfortunately, reservation has become the goal in itself. Now, even though we cannot root out the concept of reservation, at this moment, we must streamline reservation and make sure the cake of reservation should be tasted by the poor among SC, ST, and OBCs. That's all in this presentation. Thank you so much for watching. This video is presented to you by Manovidya IAS.